Thank you for your patience. It's good to see everyone here today, for sure. I guess we'll start. Let's see. We sent a first. I just a bit of a recap. We sent after the last meeting. We sent you formally our first proposal in writing. Then we sent you a CBA clean copy of the documents. And then we sent in articles, a proposal for a tentative agreement with several articles there, basically. And Joe said he received those documents, correct? Okay, I think on October 23rd, you replied that those were received. The articles of proposal for tentative agreement was there. It's pretty much just a lot of cleanup work. Is there, are you having any comments on that or anything?
What I would propose is we went through and identified the articles we can tentatively agree to get them off the table, if that's agreeable
Okay.
to you.
Sounds good. Okay.
Thank you.
Let me take up with that part.
Do you want to just go through them each? Just kind of
Yeah,
recap
well-
the view?
Like, for example, an agreement, we're good to tentatively agree to that.
Okay.
Why don't we do that, and then we can sign them
Yeah.
all at once instead of having to go.
No, so that's what we did.
Back and forth.
You have the document in front of you, so it has all the tentative agreement paragraphs, and then each page requires an initial by 'em. So if there's one that you want me to pull out, we can, or we can go through all of them so that everybody here can see what we're agreeing to.
Yeah, we can start with agreement so that
Okay.
you can see it on the screen. We're good to,
Sorry.
oh, the link hasn't been shared for it to go live?
We're working on it right now.
Okay, all right. Okay, an agreement,
But also, it should be streaming, Jeff, from the city's website. Are you checking to make sure it's not on the website either?
Yeah, that's what I was told.
Okay. No, that's fine. You're checking. Okay, thank you. Do you want us to wait, or can we? It is being recorded, so when the full video is posted.
Yeah, if you wouldn't mind, if it's only going to take a couple of minutes, I don't see the harm.
But that's fine, okay? And too many on. I tried to have it removed, but it's permanent. It's built into the ground there, so we'll do something different if we can.
So according to one of our IT experts, the link is corrupted. I went back there. You can see that it is streaming, live streaming, and it is also recording, but the live stream link is not active. So after the meeting, the entire meeting will be uploaded on the website for viewing. It just can't be live streamed right now. They're working to fix it. Apparently, it's something that happened during a few of the council meetings. They're going to work to fix it during the meeting, so the link might become available at some time as well.
Thank you.
You're welcome. So are we okay to proceed just with that information?
Sure.
Okay. So starting with the agreement paragraph, it was just the changes that you see on the page, on the screen.
We're in agreement to TA on that.
And then Article 1,
We are okay to TA on Article 1.
Article 3, I'm sorry, Article 2.
Article 2 recognition.
Yes.
We had a question on Section 3. It seems like it's redundant language. I mean, my question is, does it need to be in there?
I believe so, just because there have been a lot of people who've resigned from the union and have not wanted to, I guess, follow through with the grievance process. So we want to make it clear that regardless of their status in the union, they're still required to go through their union for all processes
You're talking about people that have resigned?
from the union.
Oh, that are not members of the union.
Correct. But they're still required to follow the terms of the agreement as it relates to grievances and any and all other processes.
Right, because if they're employees, right, they're covered, they're part of the bargaining unit.
Correct. Which is why it says regardless of their status in the union.
Okay. We'll hold on that one. We'll need to discuss it further amongst ourselves. Article 3, discrimination. Should it say non-discrimination?
I didn't name it.
just a thought came into my head right now.
I didn't name it.
Okay. What is the objection to possibly looking at naming it something else?
I have no problem with
I
non-discrimination.
mean, I just saw it, discrimination just kind of slapped me in the face. If you'll consider that, then. Other than that, it's good to TA. It's okay to TA.
Just with the change of non-discrimination. You taking notes?
I mean, does that make sense, or is that just me?
We're good on it.
Okay,
This makes sense.
thank you. On Article 4, management rights, you added full direction. Is that word needed? I mean, we understand management rights. We understand the employer has specific rights. The association has rights as well, as well as the rights granted in the contract or that we've agreed to in the contract.
Is that a question or?
My question is the word full necessary? If not, we can move on and you all could discuss it.
Yeah, we'll discuss it.
Okay. Article 5, general provisions. We had a question on Section 3. Is this language necessary? I mean, if the union gets an electronic copy,
That's the current practice right now, so we're just formalizing it in writing.
okay. I guess we can counter that one.
I'm not understanding. What did you say?
So we can offer a counter.
Oh, okay.
I mean, we don't believe that the last portion of section 3 is necessary. We'll give you a counter. How's that?
Sure.
Okay, thank you. On union business, we're gonna have a counter on that.
What section are you in now?
I know the current language is immediately correct on the written list, and you propose going with 1 day on section 1?
I think he skipped over there.
I'm sorry.
Yeah, what's,
Article 6, I'm sorry.
Okay,
Article 6, union business, section 1.
okay.
I think we're just going through the proposed TAs right now.
Oh,
and
sorry.
That's one where there's probably
Kelly.
gonna be
So,
some.
yeah, I'm on this, I'm here.
Thank you. I'm in another zone.
Yeah, I
Yes,
think you're
thank you,
working, I
thank
think you're
you.
working from two documents. I'm on,
Yes. I
we're on
am.
the TA agreement. So the next section would be
Hold on.
seniority. It's in front of you.
Yeah. I've been looking at my notes. Yeah, no. I'm running through your proposals because there were some word cleanup.
Well, I guess at the beginning of the meeting, we said we would start with the TA agreements, and so not necessarily working from the proposal document. What's on
Okay.
the screen is just those.
All right,
So I guess if we can agree to the document, the TAs, then we can go back through the proposal.
okay. Let me backtrack then. Article 5, we'll skip over. And then we skip over that we're not okay to TA on it.
For which one? Article?
Article 5,
Yes, sir, that's what you said. We're on seniority and promotions now.
yeah. In Article 7, your proposal is to add another assistant chief, correct? Currently, there is one,
Yes,
and you're adding another one?
yes.
Okay, we're not in agreement with that. Article 11, sick leave, we're good to TA that. Article 12, bereavement leave, we're good to TA on that one. On payroll deduction of dues, we have a counter, so we're not good to TA on that one. On base rate of pay, we found a typo. That's Article 16. The next to last sentence, it says 1V. I'm assuming that it's supposed to say 1.5. 1V2.
Okay. Other than that, making that change, would that be fine?
Yes, that's fine.
So the sentence will now read, overtime shall be paid at the rate of 1/2 each employer's base rate of pay for overtime purposes.
1.5,
1.5,
right. Yeah,
1.5.
yes, ma'am.
Overtime shall be paid at the rate of 1.5 each employer's basic rate of pay for overtime purposes.
Correct. It's the same as 1.5, yes, sir. But different than 1 to V2.
Okay.
On clothing allowance, we're okay to TA on that one. That's Article 21. On mileage and allowance, we're not good to TA on that. We'll have a counter for you. Callback pay, Article 24. We're okay to TA on that one. On Article 25, we'll have a counter for you on that one. Article 28, standby pay. We're gonna have a counter on that for you. Article 30, insurance. We're okay to TA on that one. On grievance procedure, we'll have a counter. We're not okay to TA on that one. It's Article 31. On complete agreement, Article 32. We're okay to TA on that one.
Can we repeat the ones that they agreed to
Okay.
TA on?
The agreement, article. Article 1, intent and purpose. Article 2, recognition. No, excuse me.
Since you're holding
No,
that
we're
one.
holding that one. Article 3, we're okay to TA with the changes we discussed. Article 11, sick leave. Article 12, bereavement leave.
Article 12.
My notes are in different order. I'm sorry, I apologize.
I show 21. Do you show 21? You agreed?
Yeah, but I think I skipped over, oh, we have a, yeah, okay. 21.
24?
There's also, okay, that's not in order. 21. 24. Yeah, 21, clothing, yes. Callback pay, yes, 24. $28, standby pay. $30, insurance.
Now, I show 28 to be a counter. Is that correct?
Oh, no, oh, yeah, counter, I'm sorry. 30, insurance. And complete agreement, 32.
Are we in agreement on those? That's what they stated.
Did we skip over base rate of pay, 16? We're good on that one?
Yes, just with the changes.
You said
Change to
one and a half or 1 and 1/2,
Yes, sir.
meaning the same thing. Okay, I guess proposals that have been presented, and today we are seeing, or are you coming back with items for discussion? Sure,
Please, thank you.
okay. Come back at 10 minutes to 2, resume. Okay, we're about ready, or you need a couple of more minutes? Okay. Okay. Okay, are you ready? Joe?
We're ready.
Let's go.
I guess we can run through your first proposals on some of the questions we had.
All right, if you direct me to the page numbers, they're located at the top. I can
Okay,
make sure I scroll there for the public.
okay. Page 1, recognition, Article 2.
So can you use the page numbers on the document?
oh,
At the
sorry,
top of it?
page
Yeah,
5.
at the top. Thanks.
I'm from El Paso.
I got you. It's okay, we're gonna get together. So page 5,
Yes, ma'am.
okay, got you.
Section 2. Section 3.
Okay, so that'd be page 6.
Yes, ma'am, page 6, I'm sorry. Just a question on this section. You mentioned earlier that it was to recognize the bargaining unit members that were not in the union.
Yes,
I mean, we've already defined the bargaining unit, whether you're a member or not.
no, it's up here. It's in the same section.
Can I suggest a definitions page? That
Sure.
We have, we can put one together and you can put one together and we can kind of compare on.
Are you, so we don't have to duplicate the work? If the union's proposing it, you could put one together and we can provide edits. And that way we can just,
Yeah, that
work
sounds
from
good.
one
Yeah,
and
but
not-
I wanted to suggest a definitions page since
okay,
we've got all these terms that we're trying, I guess, to redefine. A lot of the contracts I've seen have a definitions page. That way, if there's an issue, we can go to that page.
okay.
Yep, okay. Sounds good, okay. Same page, 6, under management rights. The addition, the addition of the word full. Is it redundant? My question is that necessary language? I mean, we all recognize management rights.
Yeah, I think it's clarifying more than anything. I don't think it's duplicative. It's just, I'm sorry, did that come from I can't tell who's,
Excuse me?
yeah. Not sure who's talking. No, I think it clarifies that, as we know, the chief has the right to manage the department under 143, the full right to manage the department, subject only to the limiting provisions of the collective bargaining agreement. So I think having the word full in there is consistent with 174 in the way it describes how a CBA can limit the chief's authority. And I think it's also consistent with the principles in 143 that the chief runs the department and has full discretion to do so.
And, I mean, we acknowledge that. I mean, their management rights are management rights, and the association has their rights, and whatever is negotiated here is, I guess, mutually agreed on. But, okay, we'll take a look at that again with your answer. Thank you.
Sure.
I'm scrolling past the ones that we've already TA'd.
Yes, ma'am.
Okay. Union business will be the next one.
On page 8,
Yeah, page 8.
general provisions, on future requests for this agreement, we'll treat it as open records request.
Yes, so as I mentioned earlier, that's the current practice that we have. We're just memorializing that in writing. So right now, any request for the document outside of the one that's provided at the conclusion of the agreement would be done so by open records. If you look at the complete agreement clause, it even says that each party should keep an executed copy.
Right. I mean, in this electronic copy, wouldn't that eliminate the open records issue?
No, so if a request is made for the document, regardless of how it's requested, it's still treated as an open records request.
The request is made by the association.
So we'll give a copy at the conclusion of the agreement, a hard copy, and I think sometimes in the past, we've even mailed a copy, but we give an executed copy. They even get a copy of the the resolution or ordinance that's adopted, all that comes with the initial, and any future requests are done by open records requests.
You said here, okay, sorry, backing up says the union can elect to have a hard copy or electronic copy.
I think we've in the past provided both at the conclusion.
It's both, right? It's not one or the other?
I think in the past, we provided both, just because we've sent a copy of when it's approved by council, so that comes electronically, but they also get a hard copy on the signing day.
Okay. Can we slash the or? Hard copy / electronic copy?
What section are you in?
I'm on 3, the same sentence we're talking about. The union can elect to have a hard copy / electronic copy provided. Since it's been common practice anyway, here it says or.
Yeah, it does, because I think at the election of it, like I said, on the day of, at least how we've done it with police, same practice we've done today, we've given copies, but all the agreements, as you're aware, have to be ratified by council. So we sent a copy of that ordinance by electronic copy. That's the practice. If you want to formalize that in writing, we can say, I think the best way to do that is the union shall receive a hard copy upon execution and an electronic copy.
Okay. Do you want me to give you language on that? Or
That was the language I proposed.
Okay.
Is that okay?
That's good. Is that good with you? We'll take a look at that.
So just for purpose, instead of saying can elect, it just shall receive a hard copy upon execution and an electronic copy of the ordinance. So the ordinance is the one that comes from council when they ratify by resolution authorizing the city manager to execute the copy. We usually give a copy of that for records, just they can reference. If you look at the front page, you can see how it's been amended by ordinance a few times, this current agreement. So that's usually provided electronically. So we can say a hard copy and any amendments shall be provided electronically. Well, what would be your preference if we're removing the or?
I'd like to, have the hard copy as well as an electronic copy of the ratified agreement.
Okay.
But didn't it say the union can elect, so it's their choice?
Or shall have, well, right here it says can elect, it's their choice,
Like
but
this means your choice for electronic or hard copy.
that's what it says right now, yes, sir.
Shall have a hard copy, shall receive.
Okay, you just shall receive a hard copy.
As well as an electronic copy.
Okay,
Is that okay with you?
okay.
I mean, in this paperless society, everything's pretty much done electronically. I guess the hard copy would be, have a memorialized record of it.
So it'll read, the union shall receive a hard copy and an electronic copy upon execution.
Yes, ma'am. That sounds good.
Got it.
Thank you.
No problem. It does, and there's been some problems with receiving that document timely in reference to how we define it immediately. So obviously 1 day, but open to suggestions.
I'm going to suggest a 10-day, within 10 days.
I think that's excessive considering it's a list. It happens at a meeting that has
Okay.
recorded minutes. So I think 3 days,
I was going to say 5 days.
business or calendar.
Business. did you want us to provide you with that language?
Nope, it'll just read, and the union shall notify the chief of any changes to the list within 5 business days
Okay,
of the affected change.
you good with that? Okay.
Do you mind if I add in writing? Shall notify the chief in writing of any changes to the list? It usually comes in the form of an email.
That suffices?
Yes, sir, it does.
You good with that?
It does. Any other changes to that one?
We had a question on employees are expected to complete the necessary forms and return to work. Isn't that a practice that currently is in effect?
I believe that it is. This language was requested by the chief so that it's memorialized in the contract.
I want to, I'm sorry, I want to back up just a little bit. That second sentence after we changed it from 5 business days, I'm just assuming that you're going to change it on the sentence after that. I will say, I
I'm
believe,
changing it in both places.
I'm sorry.
I changed it in both places,
Okay.
yes, sir.
I just add that, I mean, I think that second sentence, I don't know if y'all see it differently, but it seems to be redundant as well. It says almost the exact same thing in the sentence above. Just wanted to point it out, make sure that it was
So what we
5
can-
business days.
We can just change it in that first sentence to say a written list. Well, the second one deals with changes to the list. So we can amend that first line to say a written list and any changes to said list.
Right. In the first sentence, it says after their designation. So I would imagine that meant when there was a change. It just seemed the same to me. Could add some confusion in there. Just still seems to all be the same. Just want to make sure that it's within 5 business
So remember
days.
the list that any changes was already in there. We just added that repetitive language to it, but to keep it concise, we can reword it to read as follows: a written list of union stewards and any change in representatives and any changes to said list shall be furnished. Does that work?
Yes, a list and any changes. Okay, 5 business days. That works.
And then we would remove the second part in its entirety, where it says the union shall notify of any changes. We'll just remove that part. Does that work?
Yes, I believe so.
Could you say that one more time?
I said the second sentence then will be removed, where it says the union shall notify the fire chief of any changes. We'll just remove that entire sentence based on the changes that we agreed to.
Any other questions on this one? No, I think,
On any particular,
union business.
okay.
That way we don't,
Yeah, an additional counter other than,
yeah, we've
we not-
straightened out the days issue.
Are we not
We have,
prepared?
we're gonna have a counter on section 5.
are we not discussing counters today?
Okay. Yeah, I mean, but I don't know if you wanted a written type.
Oh, no, we're going through it.
Okay.
I mean, obviously, it would have been nice to have it in writing, but we're here.
On section 5, the language after, on page 9, section 5, I just had a question on this language. What's the intent? I mean,
I guess I don't understand your question. It's very plain. It adds internal and regular business to clarify that. It also says just the three, but also identifies all the things that couldn't be included in being request off so that it's not misconstrued.
okay. Has there been an issue with this?
Yep.
Yes? Okay. Do you have a question? We do have written counters prepared. Can we take a caucus real quick,
Sure.
please?
Yeah, no, 15 minutes, or do you need the whole 15?
Do you,
Yeah.
I guess, is there a document that you want me to share on the screen with?
Let us take a counter. Let's do 20 minutes.
20 minutes,
15?
15, let's
Okay,
do 15.
Sounds good.
You want to get back?
I mean, a caucus.
Okay, you want a caucus, okay,
I'm
you
sorry.
do 20,
Yeah, 20, sorry.
okay. We're by the clock, we'll be back at 2:47.
Yeah, we're gonna go back to that. Okay.
Thank you. I think we're ready to commence if you are. We
We're
had
ready. Go right ahead.
We had some computer issues, so we don't have the written proposal, or counter, excuse me. Okay, Article 4, management rights, that's page 6. Oh, sorry. Article 2, that's page 5. The whole article, our counter would be to keep existing language. Excuse me?
Including neuter.
What's that?
We'll be okay with changing that word.
Okay.
Oh, neutral to neuter, oh, the typo, okay. On Article 4, page 6, management rights, our counter is existing language.
Which one was that, Joe? I'm sorry.
It's just to,
Management rights,
Okay,
Article 4.
okay.
are you proposed to changing or amending for typos or grammatical errors? Is your change just to not include the word full?
Our concern is the full. the
Yeah,
word.
so that's what I'm saying. If you can just clarify, because some of them, and it says existing language, some of them are corrections for like typos and grammatical errors. So if you could just be specific in what you're asking to strike, that would be helpful. So for this management rights, it would just be to eliminate the word full.
Right.
Thank you.
I mean, usually, once we get a T8 agreement, we go through it and fix the typos. This is a little different as we're moving along, so bear with me.
It's okay.
Yes, that was it. On Article 5, we are okay to TA. We've outlined the days,
Yes, sir.
correct? So we are good to TA Article 5.
Okay.
Right?
Are we in, I'm sorry, that
Sorry.
general provisions is the one that talked about the extra copies. So are we good to
General
TA that?
provisions,
Yeah.
yes.
So then union business was the business days.
Oh, I'm sorry, yeah.
Yeah. Yeah, so the first one, the general business dealt with the copies,
Yeah,
and we're good with that.
sorry. Yeah, we're good with the copy. We've defined the hard copy or the electronic copy.
Yes, sir. So do you need me to read it again for the record?
Yes, please.
Okay, so that one will now say, the employer agrees to furnish one executed copy of this agreement to the union. The union shall, and I guess we can take that out, because now, and just say, instead of saying one furnish, it'll just say, agrees to furnish an executed copy of this agreement to the union. The union shall receive a hard copy and an electronic copy upon execution. And so I'll also be removing the word one since it's duplicate.
Good, okay.
Okay. And that one is good to TA with those amendments?
Yes, ma'am, that one is.
Okay.
That was general provisions, correct? Yeah.
Yes.
Yeah, yes. On union business, we're gonna bring something back to you on that in writing.
Are we not prepared to present it today?
No, we're not. We had some computer internet issues right now. But we've already changed the 5 days and that to 10, the 5 business days. But we've got some other language to propose on that one.
Yeah, so I think we were under the impression as we were going through these, we were going to get a full counter before we started agreeing to particular pieces of it. So if there's additional changes that the union is going to propose, then we're going to ask that we get them all at once before we agree to any of them, including the 5-day change.
Okay, that's fair. Yes, we'll get that all put together for you.
The next one would be seniority, promotions, and demotions.
Counter is existing language.
Are you prepared to discuss that one today?
Yes,
Sure.
So given the expansion of the department, it's necessary that we include an additional assistant chief, especially given that it's a proposed that the department increase by 50 employees. This expansion is necessary to also mirror apartments of similar size in our area, as well as our police department.
and your proposal excuse me, is to appoint rather than test for that second spot.
So
correct?
that was the existing language that was already in the contract. So the only thing we're changing is 1 to 2.
Right, but I just wanted to clarify that the second assistant chief would be by
Appointment,
appointment.
just as the
Not
first.
testing, okay. Let me make that note. Go ahead. You want to ask him? We have a few questions.
Yeah. What are you proposing the role of that assistant chief be? I mean, what would he be
That's at the
over?
discretion of the chief, and I'm assuming the organizational needs.
I'm asking because you're proposing it. I would imagine there would be an idea of what that position would do before you would get it.
I'm sure he has mapped it out.
Can we get that answer of what that role would be?
If you'd like the chief to talk about it, the chief and I have spoken about it. Do you?
I don't have a problem.
So
Okay.
it's a division of, all right, so currently, the department is EMA space, so that particular chief will assume managing more operationals, whereas the current assistant chief will remain over administrative duties, so we'll have an operations chief and an administrative duties chief.
Okay. So if you were to take another member from operations and appoint them to assistant chief in an already short-staffed department, would you create another civil service position? Because that would be essentially taking someone off of a crucial fire apparatus and putting them in the assistant chief's office.
Absolutely not. If you read the contract, the only people who are eligible are of a certain rank, so grade 4, so they're not already serving on the apparatus. And what it would do is create opportunities for promotions for individuals within the rank.
Right. I understand that's what the contract says, but that's what we're here to discuss today is amending the contract so that we can move forward. Could you tell us what the current assistant chief makes, and would the other assistant chief make the same amount?
Yeah, I don't think we need to get into what the pay is right now. It's more the need for the position and if you guys agree with it, or ladies.
Okay. At this time, we're still proposing to just strike the language and go with the existing language from the contract minus the typos.
So I'll just go ahead and go on the record that that's a firm for the city, just because we believe it's a necessity in the growth of the department. The city is committed to adding those positions and providing that and making sure our department operates efficiently and effectively. So that's almost like a non-negotiable for us. So if it's a hard stance for you, then we can talk about what the union's ready to give up in exchange for that.
Well, can we put a hold on this for now, pending further discussion?
We can hold it as long as you like, but it's a non-negotiable for the city.
Okay, I'll make that note.
Okay.
So the second assistant chief appointment is non-negotiable for you. Correct? Okay. Okay. On page 10, Article 9, Maintenance of Standards. Our counter was to keep existing language.
So I believe this one can be, solved with the definitions section that you're proposing. And so I would be interested in revisiting this article after we have a definitions table to discuss it, if that's amenable.
Yes,
'Cause I believe it may be able to address it in definitions.
we will come back with that then.
Okay.
Can we go back to?
Yes.
I'd be interested to know why you don't want another assistant chief.
Yes.
we're not interested in adding any more chiefs because we don't have enough people working on the apparatus that save lives. So we're 18 short, plus the number that we have short in EMS, and we're not doing anything to change that, and we haven't for a very long time. So it's kind of like adding on a room to your house before you have your house in order. So our idea on that is we're not against having another assistant chief because at some point we will need it. Like she said, the idea is to grow the department, but the idea has been to grow the department for the last 3 years and we haven't done it.
So to that respect, I would say that part of getting your house in order is to prepare for growth that's coming. The city added new positions, and I think the problem has been filling those positions and recruiting for those positions, which I feel like is something that both parties need to kind of come together and find a mutual thing, the best way to do that. But you can't grow and then have all this responsibility and not have somebody in place to do that. So I think we aligned with that, but taking a deputy chief and appointing him to assistant chief and then appointing a district chief to a deputy chief and then moving up in that regards, I don't think is going to be detrimental to the department. I think we're constantly testing, constantly adding individuals to the department. The city has done our part in making sure that we're converting vacancies as quickly and as financially as possible. But at some point, you're going to get to the point where you need it. The contract isn't to deal with things that are happening right now, it's to plan for the future as well.
If another position was added to the rank and file, would you be acceptable to the assistant chief position since that's a concern? That's the concern?
Our concern isn't the number of people that we have allotted, it's the number of people that we have. We've had people added to our department. We don't have any way to fill them. We have people leaving our department faster than we have them coming in, and we don't have any avenue of changing that right now.
Okay. So
Which I think we might get to in a little while because we have a proposal on the table for the hiring process. So maybe we get to that point, but right now we don't have any avenue of being able to fill the positions that we have without taking away from them even more.
if we had the positions filled, you'd be agreeable to it?
Again, cart before the horse. I mean, I think once we get to that point and we actually have a way to fill those positions, then maybe it's at least something to talk about. But right now, it's not. She says it's non-negotiable. It's not really negotiable for us because we don't have any way to get there.
Okay, well, I was trying to get there.
Okay.
Yeah, I was just trying to get there, that's all.
Yes, sir.
Okay.
I think this article will probably require some more discussion and, looking at various options as far as the resolution is concerned. That's why I said, can we hold this for further discussion?
I think we addressed it. I think you said we'll hold it, but it is pretty firm on that one.
Yeah, we understand your position
So
currently.
I was just trying to find a way that we could get it compromised to where we both would get to what we wanted.
I think we can go back and have that discussion and then come back with something like that. Are you?
I'd say that there's always potential to discuss. So I think we're a little early in this process to say an absolute no, but I would like to get through the rest of our proposal, see what else is on the table, and then we can continue to discuss. I mean, we could have potentially left this for last to discuss. These aren't necessarily in a great order, just going through the page, but we're always open. Right now, we're a no on that. But let's continue to go through the contract and then have time to discuss.
Okay.
Yeah, I think it's worthy of more intense and discussion on this in order to, like you said, Mr. Williams, get where we need to get, that both sides can agree to something on this article.
Okay. Okay. Let's move on.
So we're tabling maintenance and standards until we come back with a definitions table at the next meeting?
Yes, ma'am.
Okay. We renamed this article, but it's now called Department Committees. So be on page 11.
Let me catch up.
Yes, sir.
Okay. Article 10, you changed this to just department committees, right?
Yes, sir.
Okay. We have a written counter on this article, but we don't have it to present to you. We'll just make a notation on that.
So you'll provide a written counter.
Yes, sir.
Are we able to do it verbally, just so we can get through it? Is it a massive change or just like sectional changes?
Yeah, it's pretty in-depth. And I don't want to shoot from the hip. We can hold pending our formal written counter.
VTA, sick leave, and bereavement leave. The next would be vacation and holidays.
We submitted a proposal on vacations and holidays, our first meeting. And our proposal was to include Juneteenth in section 1A.
So the city isn't prepared to discuss addition of holidays until we have a full grasp of what the contract is going to cost with some of the other changes. So we're willing to
We'll move on from this one.
to hold that one.
We'll hold that one.
There were some additional changes in vacation. Did you want to just hold it in its entirety or?
Yes.
Okay.
I've got a question on that. Do all city employees receive Juneteenth holiday right now?
Yes.
Okay. Was that presented to the police department in their last contract?
The police department also prevented a full contract counter, but yes.
Right, okay, thank you.
Okay, we're going to hold this one, correct?
The next one would be payroll deduction and dues. You said you had a counter.
Yes, but go ahead. We can address that now.
Right. I believe that it's just addressing a typo. Nevertheless, we still want to counter with it. Just on the last word, it says the deduction of union dues by employees you changed unit to union. I believe that was the unit was a typo from the get-go. It was supposed to be bargaining unit. So our proposal is to just change the word union to bargaining unit, which I believe that's what the intent behind the wording was at that
Possibly.
time.
I believe we changed, for the most part, try to change a lot of the bargaining unit just to say union because it's used interchangeably. Because a member of the bargaining unit could also not be in the union. So it's specifically limited to deducting dues from members in the union. Because you could be a part of the bargaining unit and not be in the union, which is why we changed it to union.
With all due respect, I disagree. But we've got a title by law, the bargaining unit is defined. That's the way it is. I was just suggesting the change to bargaining unit. That's our counter proposal. I don't believe it's anything to get hung up on.
Oh, no. I'm just saying the reason why we changed it is because we recognize that there are some individuals that aren't in the union but are a part of the bargaining unit. So throughout the document, we went through and just specifically said union, but left in bargaining unit when we felt like it was appropriate. If you feel like it's appropriate here, I would disagree basically because the only people who can have their wages deducted would be members in the union, not necessarily members in the bargaining unit.
That's why I'm suggesting that members of the bargaining unit covers all paid permanent employees of the Beaumont Fire Department. So that is inclusive of all of our employees. And that's what I'm suggesting is that we keep that payroll deduction inclusive of all bargaining unit members, which is all paid permanent firefighters in the fire department.
Yeah, so say if you look at the top, exactly what you're saying is correct. The language reads that way. The only reason why unit was changed to union was to identify that we will only take dues from individuals in the union.
That sentence doesn't have anything to do with that. That sentence is about the cancellations and the
Exactly.
notification of cancellations. So
So, but we will forward that to employees in the union. Do you, if you want me to, that's what I'm saying, if you want, we changed it throughout, but if he wants it to change it back to bargaining unit, I said it was fine. I just want to make sure the reason why we changed it was to identify that there could be employees who were not
okay.
in the union.
Just to be clear, we're
I
on
think
the same page.
We were saying the same
then,
thing.
so-
That's what I'm saying. That's why, that was the purpose of the change. It wasn't to clarify. But we can change that back.
Thank you. So just to
So
be
you
clear,
wanted to say-
sorry, it's going to be bargaining unit?
It'll say bargaining unit.
Great, thank you.
It's something that could be addressed to in the definitions.
Yeah, that's what I was
Yes.
thinking.
Yes.
We could address this in the definitions.
But if you want to, with that change, is that provision available for TA?
Yes.
And we can also address this in the definitions as well,
Okay, I'll make a note of that.
please.
I'm recommending that we skip over pension contributions just because that's usually dealing with compensation and we can wait till the end for that unless there's a,
Well, I just had a question. When you presented it, you were explaining that you struck out all the language that was necessary to come to this, I guess, contribution amount?
so
from the
no,
employer in the
the
city?
previous, under the previous contract, the city's at 20% and the union is, and employees, I'm sorry, are at 18%.
Correct.
The other language that's included in that contract was from the previous contract where the city and the employees had stepped up contributions. So there was no change to this section. I'm just asking that we not,
You want to hold this one then?
yeah, because there could be, like, we're not proposing anything lower or higher on the employee end, but there,
While we're addressing our counters right now, we're proposing that this stays the same as it is. So that's the city's at 20%, the union is at 18%.
and the city had a counter in our wage proposal, which is why I'm asking that we just
Yeah,
kind of move
we were
past
going to
that.
talk about that. I mean, once we got to, I guess it's on the last page.
Yeah, so we can just move past that one, if that's okay.
Yeah, we can hold this one.
Okay.
Any further discussion?
Okay. The next one, basic rate of pay was TA'd, and then we're,
Ma'am, with the typo, we'll address the 1.5.
yes, sir.
On the following article, 17, educational incentive pay, I believe we have a proposal on the table.
Okay, okay.
Yeah, their proposal was for the associate degree to be monthly, I believe.
Yeah, instead of the one-time pay.
And we'll come back with the counter to that proposal.
Okay.
Oh, yeah, it was submitted to you. Yeah, it was in our document.
It was in our first meeting.
Okay.
Yes, sir.
That's our answer to that, then.
Okay, the same for education pay and cert pay. We have proposals on the table as well as incentive pay. Do we can wait for your counter?
So I think that the city wasn't interested in doing additional pay towards educational incentive pay on either of those. And I know we were, I guess, more interested in the certification pay. We would add to our previous amendment, I think we said anyone who has a basic, intermediate, or master's, we left off basic, so intermediate, advanced, or master certification will receive those.
Can I
And so on section 2, that's what I'm saying, on section 2, we left out intermediate, and so we would amend section 2 to include intermediate.
Can I just make sure we're all on the same page with the counters? Because I think, I understand we got y'all's initial proposal. This in particular would have been the city's response to that.
Okay.
So, and right now, we're looking at the city's proposals that were presented last time and asking if there is a response to that as a counter.
Yeah, that was confusion on my part. I didn't know if you were countering or this was your first proposal. We presented our first proposal. You presented yours. And I didn't know if you were countering our initial proposals with your proposal. I mean, it's confusing,
I
right?
guess we could have renamed it counter, I'm sorry.
So this would be your counter.
Right.
Okay.
Yeah, this is the city's response.
Okay.
To what was presented in the first meeting.
Okay. I will make a note. Okay, and we'll get back to you on that one.
So I'm going to skip past educational incentive, education pay, and certification pay, and go into incentive pay.
Right, and we have a proposal as well on that, I believe.
Okay,
Is this your counter?
yes.
Okay. Incentive pay? We have a proposal, and this is their counter or their answer to our proposal.
Yeah, you said you have a proposal.
Excuse me? I thought we had a proposal on incentive pay.
Sorry, so backing up to, there's educational incentive pay, that's the first one. Are we ready to talk about, I mean, we both have two different numbers on the table or two different proposals on the table. Do we want to just talk about them as we go, or? I guess
Can
I'm
I just
confused
ask
what
a
we're
question
holding.
real quick?
Sure.
I think some of the confusion comes in because we presented several proposals and y'all didn't come back with anything at all on any of them. So we figured you were just making your initial proposal that didn't have anything to do with ours. So if that was your counter to deny every single proposal that we had, then I think that we're probably on the same page again. Because you didn't address any of our initial proposals. Did you have a problem with any of them? I think that's where we could get back on track, is maybe talking about our initial proposals and seeing what the issue was with some of them.
Okay, so you're wanting to work off of your first document and not the city's response, it sounds like.
Well, this is your response, correct?
Right.
Yeah. Okay, so we propose the associates get, a monthly, it's pay versus the one-time pay. And your answer was no, correct?
The answer was the one time, the 500, yeah. And then there were counters made on the number, the amount, under the different certification pays.
And this is. Go ahead.
Do you guys have justification for that? Why you want to deny that ability for us to receive that incentive?
Well, I think we're looking at this document as a whole, and it's hard to give one reason why we don't, because we look at it as a complete document and a complete compensation package, and we're trying to present a complete compensation package without saying this is why on one on that.
But I think if I can just add on to that, I think in looking at the numbers, there were different categories that it seemed benefit the department and the city more. I don't know that for instance, that the $500 a month, I mean, that's a significant financial increase. And I know we had checked those numbers, and we can be prepared to talk about the total that would add.
On the article that we're on right now is the educational incentive pay that's for the associate's degree, which is in the current contract, $500 one-time pay.
Right.
That's what it is. We proposed, God, I don't want to misspeak. I don't have it right in front of me.
Monthly.
150 a month,
No.
right? What did,
I can, let me see if I can pull it up. Hold on.
okay. Please, thank you. I'm sorry. I'm dealing with a stack of papers. I'm not a computer guy.
I think Cody emailed it to me.
It was $150 a month for the associate's degree.
Right, and if yeah, I'm sorry, if you would allow, Our justification behind this is that we've obviously struggled with hiring people in the department. We're looking for every single way that we can to incentivize people to come to our department to make it more attractive across the state. That's where our justification comes in, is just providing as many incentives as we can to future employees and our current employees, because retention has also been a problem.
I'm going to add on to that typically departments look at education pay as an incentive to seek higher education. It creates the ability to have higher educated members, officers, and so forth. So you end up with an officer corps that's more educated. So it makes sense from different standpoints. We look at it from a standpoint of trying to attract people with incentives, but we also look at it as an incentive for everybody in the department, because you have more educated people. The more educated you get, the better job you're going to do. So it's a benefit for both of us.
Right, yeah, I think that makes sense, and I think that's why there's been an incentive pay to begin with, but your proposal would be a $1,300 a year increase per person year over year for that baseline associate's degree, when there's other certifications that have an educational component baked in that the city is also willing to compensate for. So I do think that the city is recognizing the value of the education, which is why the one-time pay is on the table.
No.
Yeah, we could just come back to this one as well.
I guess on cert pay, I guess our proposal focused on the ambulance assignment pay, correct?
Under certification,
And the certification as well.
yes.
Is this something you want to come back to?
Yeah, I think it's something we need to come back to, just because there's some ongoing issues with that as well.
Okay.
Yes.
So on that topic, there is some ongoing litigation related to who's driving the ambulances. I submitted a request for the union's counsel to attend any session where we're going to discuss that particular topic, to ensure that there's no issues with the representation in the lawsuit and any problems here. We've not received a response to that. That was, I think we sent about 2 weeks ago, and gave notice that would, when the meetings were scheduled, and requested that they be involved and participate in that. So we're, as far as we're concerned, ball's in the union's court on that, to have counsel here to make sure that there's no issues with the lawsuit that would be involved in those discussions.
I was in contact with our lawyers about this question, and I may have missed the beginning, so please correct me if I'm wrong in anything, but we're addressing the ambulance assignment pay of $50 per shift for employees who are assigned to the ambulance. That's what we're addressing. We don't believe that has anything to do with the lawsuit. This has to do with any employee who rides the ambulance to be paid an assignment pay for being on that ambulance. No different from any employee who is assigned to a day's shift receiving an incentive pay of $250 a month. This would be an ambulance assignment pay for any employee who is riding the ambulance. It has nothing to do with the lawsuit.
You can hold on that. That was your suggestion? Yeah.
That brings us to incentive pay.
We haven't finished with the certification pay.
I think
I
we,
don't-
I think we did. It dealt with the ambulance.
Sorry, we have not discussed all of the certification pay. So, give me just 1 second. So are you just wanting to hold on the entire section, or are we just holding on this ambulance assignment pay? Just to
So
be clear.
we didn't counter on the ambulance assignment pay because of the things that Kelly mentioned previously that obviously you disagree with. That's why we didn't provide a counter to that. Our certification pay is a counter to the previous certification pay that y'all presented, similar to that. So I think it was your credentialing pay counter is what we countered in our certification pay. We didn't provide an ambulance certification counter because of those reasons.
Okay. We do have Cody, Cody's going to read what we have here.
I am sorry. My computer's giving me trouble, but
I gave you a hotspot.
I know. It wasn't very strong back there.
It moves, Cody.
So, anyhow, so we originally proposed the advanced EMT and paramedic pay along with the E2, E3, and I think that probably caused a little bit of confusion in the beginning because we have some EMTs that have elected to take that training and get that credentialing. So looking at what you brought back to us and having the opportunity to explain that, where we got to that 350 for advanced pay and 500 for the paramedic pay is looking at other departments that are fire-based EMS departments and looking at what they do and what works for them, what has attracted people to a fire-based EMS system, because it is very different altogether, especially from a recruitment standpoint, and retention for that matter. So I think a good counter for us would be to, after, you have it up? Yeah, after, do you have the one with the edits?
No, this is what you provided to me last meeting. I have the edit one. Do you want me to pull that one back up?
Yeah, bring that one back up. That might make things a little bit more simple.
Okay, hold on. Hold on. Let me find it.
And just to clarify, that ambulance incentive pay was a altogether new article proposed, so we don't have to include that in this certification pay section. We can move on from that and come back to it later. Yeah.
Okay. So it's broken into 2 pages. So it starts here and then it goes here. So you just,
Okay, so, yeah, right there. So after medical director there on the bottom line, you want to strike through as, and then move on to the next page, and then strike through E2, E3, P1, and then strike through your language about your proposed amounts, and then return it to $350 and $500 respectively. That would be our counter, is to go back with what we had before.
so I think we were willing to discuss dollar amounts, but the language regarding credentialing would need to be necessary since the EMS employees and the individuals at work have to work under the medical director. So it would need to be clear that we're working under his procedure. So we're willing definitely to discuss.
So it still says we're credentialed, so who are also credentialed by the employer's medical director. The reason for the subtraction of the E2, E3, P1 is those are letters and numbers. They're They're,
It was my understanding from the chief that those are how they are identified
right now.
under the credentialing process. Yes.
But that doesn't necessarily mean it's going to stay that way. But the credentialed part is going to say, everybody has to be credentialed in the system. Are we going to keep it named E2, E3, or
I get
are we
that.
going to start calling it
So,
F5?
but could we leave it as
N4?
also credentialed by the employee's medical director? And then we can include different language instead of at that. Can we just say at a higher or at a recognized higher rate so that it doesn't necessarily identify any of those, but identifies a higher level of credentialing?
Well, those patch levels would be credentialed to those patch levels. So if I have an advanced EMT certification, I'd be credentialed as an advanced EMT, and I would function as an advanced EMT in the system. The same with paramedics. That's essentially what we're proposing, along with, we can talk about the numbers, but I'll add too, before we get into the pay, the other part that we were going to propose is adding a section 3. And this is where I guess it gets difficult with me not being able to, I might be able to email you just this one document. But to add oversight for the credentialing process will be the responsibility of the fire department's training division. The credentialing process will be completed for any member of the bargaining unit who desires this training within 6 months of the ratification of the agreement. And the reasoning behind that is we've had members who have elected to go through this credentialing process that have taken over 2 years to get credentialed in the system. So no matter what pay we attach to these credentialed levels, it doesn't make any sense to us to negotiate an incentive into the contract when they're going to spend half of the life of the contract trying to obtain that incentive.
Okay. So just so we're clear, we're removing just the letters. And then we'll just negotiate the dollar amounts.
If you remove the letters, how do you know who gets what category, I guess?
Because an advanced EMT gets that amount and a paramedic gets that amount.
Okay, so
You don't need letters to you just go by the patch level. That's what we're proposing.
Okay.
Stick to the patch level. Be credentialed in the system so that you can function at that level, but just stick to the patch level. So you don't complicate it. It complicates it when we start bringing in, random letters and numbers that we've created designations for.
Okay. I guess I'll need to do some research on patch levels to make sure, to see the best counter language, so that there's no ambiguity of it, so we can at least have some understanding of what that looks like, if that's okay.
Okay. Y'all want me to, I can send that to y'all.
Yes, sir.
That way you can look at it. Thank you.
Okay.
And are you talking about just 2 levels?
Yes.
Okay.
Advanced EMT and paramedic.
So what about the intermediate paramedic? Can they not qualify for additional credentialing?
So the intermediate designation actually changed. So the Texas Department of State Health Services changed that to advanced EMT. So advanced EMT and intermediate are synonymous now.
Okay. That helps. And then the section 3 addition was to provide a schedule, a timeline, right?
Correct.
Okay. I'm just making notes. Are we ready to move to incentive pay?
Just real quick, you said you had some comps on the paramedic incentives? Did I hear somebody say
Yes.
that?
Yes.
Are y'all able to share what the comp cities were?
Sure. We'll get it to you.
Is it the same list that you got the wage comps from? Do you know?
No, I think there may be others. We'll take a look and get it to you.
Does this one tie into what we were just talking about?
So, and so this is a little different. This one does more with our special teams. The type, we might need to, at some point, at the end of it, kind of go through and maybe retitle some of these and combine some of these articles. I think in the origination of the contract, they just started adding articles and not necessarily thinking about which ones can be combined, because technically education pay could just be one entire
Yeah,
section.
I was thinking some of these can be combined.
And that's like towards the end, we could probably.
Toward
go
then, we
through it.
could combine and renumber.
Yes, sir. And that won't impact the TA agreements, because those are just language, but I think some of them can be reorganized. So this one deals more with the special teams and operations. We took out the section 2 because we added that language under credentialing. And
Is this
then-
one you want to hold?
So this one's not like, there's no really major change to this one other than taking out section 2 because we added it to credentialing. So regardless of what happens, the language is still there. It's just in a different section.
Right, and the additional language is the fire chief shall have the right to eliminate or create teams with the city manager's approval.
Yes, so that's the additional.
We have a counter?
So we have a counter to that. The counter would be the fire chief shall have the right to create teams with the city manager's approval, striking eliminate or. We feel like allowing the chief to eliminate any special teams that we have currently moving would give the chief unilateral authority to be able to take pay from members during a contract and which, or benefits. For example, I would say that I could be on the hazmat team making an extra incentive pay to be there. This would give the right tomorrow for the fire chief to be able to eliminate that team, which would therefore take money from me during a contract period. So we feel like that we would need to remove that language to
So I also think it
eliminate.
goes that to the right, the chief has the control over the workforce. So if the chief believed that, well, not the hazmat, I think that that's a bad example because we live in Southings, Texas. Hazmat is necessary. But some of the other teams that might become redundant or need to be merged to another team, the chief would have the ability to either eliminate or create another team for that particular purpose.
I'd be open to discussing the creation of new teams or the elimination of teams during the contract negotiations.
So I know,
However, management rights does give certain rights for management, but also our maintenance and standards gives rights to protection of our benefits. And I believe pay for our members would be considered a benefit of our members.
I mean, I don't disagree. I just think that there's as a fundamental right to organize the department and be as efficient as possible. If there's a team that's being underutilized, but members are being paid, but they're not, they're just on a team that doesn't serve the department. I mean, there could be an amendment that says that notice can be given to the union prior to the change. I know we have that in some of the things. So if there's up for discussion,
Can we just talk about which teams he wants to get rid of right now?
I don't know that he knows.
Well, then let's just strike it and not worry about it.
Again, the contract is not intended for things that happen today, but intended for things that could happen in the future. So the compromise language would be to identify the union of any proposed changes to,
Well, that would
special
just be,
teams.
that would just be letting us know that he's doing what we don't agree with.
and if you object to it,
We object to it.
then you could talk about it at that time. Because it could be a team that you agree that, yeah, it's not necessary, or yeah, we agree that that team could be reorganized into something else.
I think he probably has an idea of wanting to add or take away teams, or we wouldn't be putting that in here. Would you agree?
I wouldn't, I added it.
What was that?
I said I wouldn't agree in discussing that was a change for me in terms of, I asked him for a list of teams that we had, and he specifically said we may or may not need some of these teams moving forward. And so I added that language and chose not to list, instead of listing all the teams that we had in the contract, just chose not to do those and just say that he has the ability to add or create teams.
So again, our contract negotiations, that's what this is here for, is to to discuss the benefits of our members. That's what we're here. If the chief has things, or if you have teams that you would want to eliminate or create right now, we could address that. But our contract also lays out that we can reopen the contract if mutually agreed between both parties. And we could come back and discuss those if the fire chief ever decided that he wanted to change something involving special teams.
You looking at?
That's fine.
Do we need a Congress?
So we can hold that one.
Yeah.
And we'll provide a response to you at the next meeting.
And that's what I really like to do. I like to hear all of this, and then we can provide a response. But we're reserved the right to ask each other questions right now. Okay.
So is that the only major change for that particular one?
That's the only major change, right?
Yes, but I think that would probably be where we would put that ambulance pay, just because the ambulance pay is an incentive, unless we just want to completely skip over that right now and make it a whole article in itself if we can come to an agreement on
I
that
guess we can
later.
talk about like reorganization. Mr. Tizzin just kind of said that towards the end, we'll look about cleaning up some of the articles, kind of reducing them in general. So wherever, there could be some other things that we decide can be shrunk down, because we could put wages and pension can go together, and we could put all additional pay under one particular article and then bullet point it out between incentive and educational pay. So I'll just make a note that that's where we would, if we added it, that's what it would go, and go from there. Does that work?
Yeah, we can combine and renumber as needed towards the end.
Yeah.
Work for you?
And we don't want to not talk about ambulance
Right.
pay. We just have an opinion that we don't feel like we should be talking about it. So if you get an opinion, and it would be good if you got your attorney to say, okay, that we're okay with talking about it and putting it on the table. We just want to make sure we're in the right position to do so.
Okay, are we ready to move forward? I think there was we TA'd clothing.
Yes, we did.
And then the mileage one is, I think, I have a note that we had to come back to counter. I will tell you that we removed section 1 just because we no longer have that practice. It was my understanding that most people drive themselves between stations now.
Just something that comes to mind with that. We actually have some members that run to work. So there are, and people that carpool. So there's occasionally a situation where somebody would need to get a ride somewhere once they report to the station and then they're moved. That's the only issue with that. I don't know that it really changes anything by taking it out. If you leave it in there, then it leaves us open, to flexibility for out of the ordinary situation.
I'm okay with that. I wasn't aware. So we're fine to restore to normal language.
Okay.
Okay, so you'll restore.
But it would not apply to individuals. Can we just add that it doesn't apply to individuals that have transportation? So if someone does have a car but doesn't want to drive it, like that individual would have to drive between stations. So we would limit it to individuals that didn't have transportation.
I think we could.
Is the notification made prior to the shift? Like 3 days before? Or
So it
shift,
has it out.
a shift?
It doesn't apply to personnel who are notified to changes prior to reporting to duty. So in some cases, I guess it could be, but I do know that there, in the past here recently, we have had a lot of shifting while on duty in the middle of shift. So I can understand if maybe somebody who came to work, to Cody's point, somebody who came to reported to Station 1, which is downtown, and then had to go all the way to Station 8, but maybe their wife has a car that day, they would obviously need to be transported from that station. But somebody who had a vehicle who just didn't feel like driving to Station 1, I feel like we should clarify that they wouldn't be transported.
If a person was moving from one station to the other during their work schedule, they're not released from duty. and that person were to be involved in an accident, how would that work as far as workers' comp? Are they still considered on duty? I mean, it just raises the question to me that if something was to happen during the transportation from one location to the other and they're in their own vehicle.
It depends. So if they are in their vehicle and they get rear-ended versus if they're in their vehicle and they run a red light. Course and scope of deployment, the same rules would apply. Course and scope of deployment would apply. Same as our other individuals who drive their personal vehicles for work-related incidents.
I think another issue that kind of complicates this is how do you word everything that you're saying? Because we also have individuals with motorcycles. So you show up at your permanently assigned station with a motorcycle and you get moved somewhere. The way that you're proposing it is they have a vehicle. It's not that they don't want to drive it somewhere, but we have a lot of baggage with our motorcycles, or with our, when we're moving around like that. We also have bicyclers, people that ride bikes. Or, I was gonna say, if you just leave it the way it is, I don't think is anybody abusing that? Has there been a problem with it?
I think it was more like a resource thing. It's like not having to put somebody out of service, but I can revisit it and make sure that if it's not a resource issue, if it's not a question of resources, then we can leave it the same. We can come back to that.
Because this type of article opens a can of worms. We dealt with it in El Paso, where, transfers happen, stuff happens, you report to duty. Most firefighters come to work an hour, half an hour before duty, and they relieve their person. And there has to be, transferred. The question of workers' comp, are you covered by insurance? Do you wait until your shift actually starts? Do you get mileage? So it's one of those can of worms kind of, or could be a can of worms kind of article.
Okay.
Can we hold on this and
Sure.
reconsider it?
Yes, just a question for my benefit. Do most people prefer to drive their own vehicle or be driven somewhere in y'all's experience?
If you're notified with enough time, like your last shift, you're told you're gonna report to station, whatever, your next 3, then you know where you're going. But staffing changes and you report to station 3 and you're told to go to station 25 on the other side of town. Is there a mileage allowance? Are you covered if do you need to be on duty? All those questions come to light. So
So the city doesn't pay, like the second section wouldn't apply because we don't pay for travel within the city. Civilians doesn't get that. So that would answer your question, but I understand the concerns about insurance and workers' comp. We can look into.
we could hold on it.
Yeah, I can look. I guess I'll research whether or not it's a necessity.
To answer Mr. Williams' question, on a normal day-to-day, this doesn't happen. We don't have chiefs driving people across town. Like we suggested before, it's just taking this out opens a can of worms with so many other questions to clarify everything that's happened. I don't believe this has been an issue in the past. Most people do prefer to drive their own car because they have, like we spoke about, their bunker gear, their bedding, their food, so on and so forth, that has to go with them when they get moved from one station to another. And they would prefer to drive their own vehicles, but there are instances where they can't, or it's just very inconvenient. Again, just proposed to leave it in there. I don't believe it's ever been an issue. I mean, if it has been an issue, maybe the chief would speak to it, that maybe he could speak to how often it happens. I'm in no way able to tell you that if it happens, whether or not it happens every single day, but I don't believe that it does.
And to answer Mr. Williams' question, and not to be too silly, but we prefer to take our car because when we come back, we don't want to find it on blocks or filled with AFFF foam or on sandbags.
Thank you. Thanks for the information.
That used to happen in the old days. I don't think it happens now. Right, Chief? But if we could just hold on
Appreciate
it,
that.
maybe.
Yeah, we can hold on it.
It appears that there used to be a mileage allowance and that was done away with this article.
No,
Historically.
so the car allowances were always aligned with the civilian policy. So, and we don't pay for in-city travel.
Can we revisit it and do a little
Yeah,
more?
no, I have a note for
Please,
that.
thank you.
So moving on to hours and overtime pay. This, section 1, didn't have any change other than to, update it to the current rate. And then, section 2 had changes.
What's that? You're striking the last sentence, correct?
So on section 1B,
Yes, ma'am.
yeah, no, it's just changing it to adjust it. So that last section on October 1 in the previous contract, it increased to $250 a month. So we just said that the rate is now $250.
Okay.
So that was just, I just removed the increased language from the previous contract to state what the current
So it
rate is.
stays at the current rate.
Yes, sir. So that's what I'm saying, the only change was in section 2, paragraph B.
Do you have any reason why that article needs to be changed?
Yes, there was a concern about overtime.
Could you tell me how overtime, how does that affect overtime? I'm not aware of the concern. Could you explain that?
The rationale that was given to me was they were concerned about overtime and that there wanted to be clear language as to the hours of the chiefs in that department.
You have a question?
Are you aware that the minimum number of people working in that office has already been lowered to 3? I'm sorry, to 2. You're right. It's already at 2. So if this passes, then when they go on their lunch break, there's only going to be one person in there. You have to call overtime for that. If it's allowable, we have somebody from that division and he's an alternate. We can just have him speak on the effect of that change, if that's okay. Is that allowable for, everybody's okay with that? Up there or
Okay,
right
Mr.
here?
Williams?
No, a contract allows for resource personnel to speak.
Yeah, under the proposed.
Brian, we're actually speaking to the mic so that it's properly heard and recorded.
Okay, under the proposal, moving the schedule from a Tuesday through Friday to a Friday through Monday actually reduces the time that you have the most staffing needed during the week. That's our busiest time. By making the 2 positions take a lunch, depending on the staffing, you'll actually be having to call in somebody to cover a lunch period. So the call-in is a 2-hour overtime. So you're actually creating more overtime. But the main thing is you're reducing the work staff that you needed during Monday through, or Tuesday, Wednesdays, and Thursdays. Those are our busiest times of the year. Of the week. Putting them on Friday, Saturday, Sunday, Monday, you run into the same problem. If you have to take a lunch and there's only 2 of you, you're needing to call somebody in to fill that spot.
So is a concern about having to take a lunch?
Yeah, there's no reason to. And if you give these 2 positions lunches, we have dispatchers in there working 12 hours that don't receive breaks or lunches as well, which I believe PD does, get breaks and lunches. So if we're going to start doing lunches and breaks, then do we want to do that for all of them, which will be an extensive amount of overtime to cover those positions? And I believe we were under budget on overtime last year in that division as well.
Could I add a point to that?
Go ahead.
The other thing it does is if you take the chief of the communications office and the assistant communications officer, who in that capacity, the assistant communications officer is the one who trains everybody that goes up there. So if you take those two people and you put them on these different shifts like that, you're going to end up with the least tenured in those ranks. You're not going to end up with experienced personnel like you have right now. You have a captain that's been with the department for 25, 30, 27 years. Hebert's been here. He's the chief of communications. He's been here for 34 years. Those are very important positions that provide a lot of information to the newcomers to that division to do the right job in there. And that job in there is very stressful and it's very important. And you have to think very quickly. So you have to be trained really well. You take those two positions and you start messing with the schedule and making it especially a Friday through Monday, nobody's going to want to be in there. You're going to get somebody that doesn't have any idea what they're doing in there. It's not good from an operational standpoint, and it doesn't make any sense from an overtime saving standpoint either. We did have an additional question on that too, if you're ready for that. Yeah.
Also, currently, we do eat lunch while we're working. So when we're working 7 to 5, we're actually at our desk answering the phones or doing what needs to be done as far as the training while we're taking a lunch. So
Okay. That's where I had lunch today. It's at my desk. He interrupted me. Yeah, and I think overtime is a concern here. This is one we'll look at and see what it means. We'll hear what you have to say, but we've got to do something here because this is, and you look at the numbers, you're saying it might increase over time, but right now, these people are accumulating huge amounts of overtime. So we need to fix it some kind of way.
So the issue is the overtime usage in this particular communications center?
Yes.
Okay.
One more question on the last sentence of that article. The fire chief shall have the final authority over the assignment schedule. What's the need for this language to be in the contract?
Just so I think it was clarifying language.
Are we going to clarify what the assignment schedule is here in this negotiation?
I think that's part of could be a part of the definitions table if necessary.
I think kind of what he's getting at is the way that it reads, it seems like he can change the schedule anytime he wants after this contract is ratified. Is that the intent?
No,
What is the intent?
it's an effort to make sure that there's not excessive overtime in that department.
No. I mean, just with that sentence.
That's the intent, to make sure this chief will have authority over the assignment schedule so they can make sure that he's monitoring the overtime in that department.
Right, so if we set the schedule in here, which is kind of seems like what y'all are trying to do, then why would you need that language?
Not that schedule. I'm sorry, not that if we agree to go to 7 to 5 and remove the additional days, let's just say we took out all of that language and the schedule remained the same. If people were coming to work and being assigned to work their regular work schedule, it would be so that he could review what the overtime usage is and make adjustments as he saw fit, not the time schedule. So not the Monday through Friday or the 7 to 6, that would be contractual. It would be the days and times that they are assigned for overtime. We can clarify that if that's necessary.
That's pretty confusing. I think some clarification on that would probably be good for all of us. 'Cause that doesn't really make sense. You lost me, sorry.
That's okay.
Doesn't the fire chief have the authority to assign a schedule?
So right now, I think the chief, that communications falls under a different chief. So if there was a problem with that, this gives the chief the ability to adjust it based on what he feels like is a need for overtime purposes. The intent for most of the city's changes deal with curbing our overtime costs as much as possible to make sure that we're making the best decisions and utilizing our resources effectively. So it wasn't intended to be confusing. It wouldn't give him authority to change any contractual language, but it would give him the final authority to maybe say, no, this person shouldn't be working this day if they've already been off, or this person's going to be on overtime and has already worked several overtime hours this week. It would give him the authority to make the best decision for that.
Okay, so it has to do with who's working overtime, whether they've been sick. Does it have to do with that? Because that's covered in a policy.
It is, and I think that
policy.
this particular division is my understanding that there's been some problems with that. So this will give the chief the authority to correct those issues.
Yeah, what is the problem in that division?
Abuse of overtime.
Abuse of overtime?
There's excessive overtime from that department.
Misuse of overtime?
I think there was excessive overtime from that department.
I think
Yeah, and our goal certainly is safety, and we want to do everything to make sure we provide the service that we need to provide. But in some of the things we're looking at, what we've been reported, these employees make more than anybody in the department. And we're looking at some ways to curtail overtime and put it in a position to make sure that we're working out all the areas to get it under control.
Right. Well, just as a statement, we are all aware that the department is short-staffed. That is definitely causing an overtime issue in our department. This office has already been cut. The minimum staffing was 3, maybe a year and a half, 2 years ago. I would have to ask for that. It was reduced recently down to 2 in that. We're already risking, efficient operations in that office with the minimum staffing being that low. Again, as Chief Hebert explained, we have a minimum of 2 in that office. If you send someone on their lunch break, someone will have to fill that position.
Oh, no, I think we've already addressed that. We're going to look into that. I think we're solely on that last sentence. I didn't disagree. I heard the comments made by Chief Hebert and
I guess I'm just readdressing that because you mentioned an abuse of overtime or excessive overtime, and that's why he has the final authority for the assignment of the schedule. And we're just not real sure what that means and why the schedule can't be set and everyone understand what the schedule is moving forward. I believe that the one hangup is that there's uncertainty. What is the shift? What are we proposing here?
So the assignment schedule wouldn't impact the number of shifts. It would literally impact, and maybe it's the term of language, a term of art. And everybody has a different language, but I know that the schedule is made for operations like every 3 days. I think they work days, so their schedule is kind of put into place on a weekly basis. So the chief would have ability to determine, looking at the schedule of individuals who are scheduled to work, whether or not that's the most efficient use of overtime resources. Not changing their 7 to 5 or not making somebody take a lunch or not go to lunch. It would literally just be to make sure that there's not excessive overtime coming from that department.
Okay, I think we can just revisit this.
Okay.
Call back. We TA'd on that one.
Yes, sir.
On Article 25, our counters to keep existing language.
So again, the dive team would not be recognized under incentive pay since we moved that under all teams. So there's really not a big change in this department other than we now recognize a dive team as a incentive pay, because if you go back to that incentive pay language, it does mention the special teams. So dive team would be a special team.
So those would fall under the reorganization we've been talking about.
Yes, sir, sort of. It's one of the original cleanups I mentioned. Like this particular one could just be industrial fires because the dive team is the only team that's specifically listed in the contract. The other ones are just identified as special teams.
I can agree with you on the restructuring that the dive teams could be moved around in the contract. However, this is addressing taking away the double time pay for when the divers are activated, when the dive team is activated.
We can move
And-
that language.
I'm sorry?
We can move that language.
I'm not, it says you're striking that language.
No,
I'm
I was-
wondering, are our divers still going to receive double time pay?
Yes, I'm saying we could just move that entire language. I was just pointing out that that the special operations team or the dive team was the only one that was specifically listed out. So if it's to ensure the benefit remains the same, we can just include that language under incentive pay since that's where all the other dive teams are. Yeah, so
The only concern was just taking away the double time for when they're activated.
So it'll just say they'll receive the incentive pay, so we can specifically list it out under incentive pay.
I understand, thank you.
So I'll just move that language. Are there any additional changes for this one?
On,
It'll be just industrial fires now.
right, and then we can look at, once we reorganize, moving this section into the
No,
other one.
I made a note to move the language to incentive pay. So if there's no, I guess, changes for the language in industrial fires, we can mark it for TA and we can make sure that the language appears how it's supposed to in that other section before we sign off on it. But I just agree that this particular one, regardless of how the language maps out, shouldn't be with industrial fires.
Yeah, in principle, we can agree to that, and once we see it or formally have it moved over, we can officially TA on it.
Okay, I'll mark this one and then we can kind of go from there. And then temporary promotions was the next one.
Okay. Our counter was keep existing language. Correct?
Yes, that is our counter for that, is to keep existing language. We also, this article also runs along with a policy that's in our department that has been in place, I believe, since 1999, and also some of your portions of this, which, talk about some of these upgrades are protected under civil service statutes too, about members working outside of their classification being entitled to the pay of the higher classification. So again, our counter proposal is to leave this article the same.
So I don't believe that we took away that. I think we just said double upgrade shall not be permitted. The only other major changes would be that upgrades or cannot be turned down and mandatory, and that's so that we have the most senior person working in those positions during this time. And then that's section 5. And then section 6, again, was to, try to have the most efficient possibly, so we're not changing and making major schedule impacts after the shift starts. And so these are more efficiency changes. And to Jeff's point about the policies, I think at some point with the change and the increase in the department, there's going to be some policy changes, which is why we propose to have a operational committee and a department committee thing so that the union would have a voice in some of these changes. Policies from 1999 are not going to be the best way to move forward in a department that's now fire-based EMS. Because I don't believe that those policies at the time that they were written anticipated some of the challenges that are being faced today. And so that's kind of one of our major impacts for putting together or proposing that committee, was so that both sides can sit down to do that. But the changes that are being proposed in this particular one or essentially for efficiency in the operations, and to make sure that when people are upgraded, it's the most senior person, to make sure, for the reasons Cody mentioned earlier, we have the most senior person and the best person in that department, in that position leading at that time.
So just to ask, you mentioned policy, and I think that there's several other places throughout your proposal that address policy-related issues as additional contractual language. So if we're not going to talk about policy, I think it probably makes sense not to add policy items to the contractual language. That being aside, Section 5, when you say, upgrade shall be mandatory and cannot be turned down, you say that that's so that the most senior person can be in that position. So I think that it's important for you to understand how our department works and the culture that's there, because that doesn't necessarily make sense from a functional standpoint. So I'll give you a few examples. We've had members, very tenured members, and I'll give you a personal example. Whenever I was a really young firefighter and I was being upgraded to drive, I had very senior firefighters that were on the back and I was driving. They had time on me, but they turned down the upgrade and I was able to learn from them while I did the job. So the same thing happened when I was a really young driver, working with a very tenured driver who just turned down the captain upgrade. He's driving, I'm captain, I'm upgraded to captain because he turned it down. It was his to turn down. So I get to ride with him and I get to listen to him because he's got a lot more experience than me. It doesn't mean that I can't do that job as captain. It just means that I don't have the experiences that he does. I don't have the life experiences or the job experiences. So he has perspectives that he can help me with, and he doesn't want to do that job anymore. He's a few years away from retirement. He doesn't need to do that anymore, but he does want to help younger firefighters learn. So we still have members that are doing that today. We also have situations, and I'll give you another example, where you have a driver. He's a driver. You can have a bum knee and still be a driver. You can't have a bum knee and crawl through a house that's on fire. So he's still perfectly capable of doing his job as a driver, but he needs to drive. He doesn't need to take the captain upgrade. There's personal situations. People go through personal life situations that make them not completely focused on their job in the way that they have people's lives in their hands based on their decisions. Did I say that? But anyhow, they have personal situations that can distract away from doing, making important decisions that affect people's lives. So there's a lot of situations that factor into that say that making it just flat out mandatory is not a good idea for anybody. I think I probably understand why you're wanting to do that, but it's not going to work well at all. And we're very opposed to that,
So to counter that, to your point where you said a driver can do his job, but just can't be upgraded to captain, I will remind you that the job description of a captain says that you have to perform the next higher duty. So that probably wasn't the best example to use. And so we take that in consideration as well, that when you promote and test up, you have to be able to perform at the next highest level. That's the assignment of the job.
I guess my point to you is that
I'll take the other part under the consideration and refer to the chief in terms of that. But
Gotcha.
the recommendation or the understanding was that a lot of the issues have been having when you have someone turn down the upgrade and the district chiefs or the deputy chiefs have to figure out and move people around throughout the station. That takes a lot of time and a lot of manpower, especially in the middle of the shift. We can come back to this one because we did propose under some other things that we take the vacation and time off be only done at the beginning and the end of the shift. That could also probably mitigate some of the concerns here as well.
You want to hold on to this one for now?
What I'm saying is that I think it's something that can be discussed in totality with other parts of the contract to maybe alleviate some of the things, some of those concerns. I don't think we're ready to kind of yay or nay it in terms of changes right now, but I did make a note of what you said. I just think that there needs to be a balance of department efficiencies and operational efficiencies moving forward in an effort to try to reduce potential grievances and on both sides in the future. So if you're saying that this is not the best and most efficient way to do that, then I said we did propose some other things that may be able to accommodate that and where this language isn't necessary.
Well, thank you for listening to our concerns.
I do want to add one more question. I mean, do you believe that when we staff the department that this problem would be diminished? Right now, we can see where there's a struggle and a lot more work that the deputy chiefs are having to do at this level to keep up with temporary promotions because of the number of personnel we are short equates to the number of personnel we have to temporarily promote on a regular basis. I believe, in my opinion, our suggestion of keeping it the same is that there's no need to change this. When we staff the department, this process that has been in place has worked for decades, and we haven't had issues until we became short-staffed. And now it's an issue, but we believe that this problem will be solved when the department is staffed. And it still gives the members, the department, flexibility to move forward.
So I think it's important to note that the department could almost never be fully staffed, and I think that no department has ever been fully staffed. I think that's something that's the goal. That's utopia, but I think we have to operate understanding that we hope to get there, but if we don't, to at least have some backstops in place to how do we address those issues if we're not fully staffed. So I agree that may not be a concern once we are, but there's the question of this is where we are right now, and we don't know how long it's going to take us to get to the promised land, so we need to plan for where we are and where we're going.
And I don't know what we're gonna get on this, but, and we're certainly not here to talk about grievances, but it seems like most of the disagreements we have are the things that come across my desk that have to do with temporary promotions. So whatever that means in us working through something to work, that makes it work better for the union, Local 399 and city management, we need to talk about it because it's a real problem and time consuming for all of us.
Agreed. One other question, Section 6, after 8 a.m. changes to the schedule in accordance with the efficiency of operations. A couple of things with that. I think it kind of goes back to how short-staffed we are. The schedule's more often than not done by 8 a.m. So the schedule's not set by 8 a.m. anyway, because they're calling overtime in pretty regularly after 8 a.m., still trying to get people to staff all the units. Along with that, the efficiency of operations is used a lot when there's a desire to not give the temporary promotions or to take some other route instead of giving a particular person temporary promotions. I think it'd probably be good when we get to the definitions page if you guys want to add a definition to efficiency of operations, because that's a pretty vague term that gives a lot of latitude to just say, well, this is better for me or for everything, and I'm not going to do it. So it leaves it wide open, very open-ended. But I think it's something that we can probably discuss. I think a lot of what we wanted to get was your perspective on why you put these changes in here. And maybe we could come back with something that's a reasonable middle ground there that might be able to solve some of the problems.
Okay.
Okay, we'll move on. We proposed we have a proposal on hiring procedures or entry-level hiring procedures. And I guess this would be your counter.
Yeah, so I'll defer to Kelly. I think we looked at some of the comparables that you sent to say that, you know, a lot of departments had went back to their original hiring practice. And from what we can tell, most of those cities were not CBA agreements, and some of them were probably like meet and confer. I didn't look to see how many of those were fully staffed departments. But I guess our contention is that, you know, I don't think that we want to change the hiring procedure just with the fire-based EMS. It's imperative that I think the chief has kind of made some concessions on doing a dual certification list, but they have to come in with their EMT certification because that's the hardest one to achieve. So we're not opposed, again, to, you know, and this is kind of outside of that, but doing a dual cert list. But the higher certification should be the harder certification to achieve would be the EMT one. So we'd be willing to send somebody to the fire academy, but not the other way around.
You said dual certs.
No.
A couple of times we do dual certs
That's
right now.
I'm saying a dual list. That's what I'm saying, a dual
Okay,
list. So
I didn't know if we were talking about a single certification list or a dual certification.
Yeah,
list,
so-
because you're
sorry,
talking about
so-
two different lists.
Yeah, so willing to do dual lists with a single cert, but the single cert would be the EMS one, not the fire certification, just because that's the hardest one to get. And the pass rates for those are very low. Also, and be willing to entertain, I know the union had at one point proposed a cadet program, willing to discuss that as well.
We actually weren't the ones that proposed the cadet program. I think that was the fire chief's idea. So if you guys want to bring that back as a proposal, I think we're willing to listen to whatever it is that you're wanting to do on that. There was something that you said that, and now I don't have it. Hang on, it'll come back to me. Yes. Thank you. So you would give, what you're saying, if you did a dual certification list and a single certification list, you would give a civil service test, and anybody that's dual certified would be on one list, and anybody that's single certified would be on one list. Is that what you're saying?
So yeah, so it'd be two different lists, yes. So you'd be two different lists, so.
One test, two lists?
Yes, sir.
Okay.
And we can talk about what the cadet program looks like, flesh that out next time if that's good.
Good, okay. We'll hold this one for further discussion then.
Yes.
Okay. The next article is standby pay. Our
sir.
question was, who are these representatives?
I believe that they're appointed, and they work under the EEOC. I don't necessarily know off top who these employees are. This was requested language from the fire chief. But it allows for I know we have arson investigators that are on standby, so this just added the other employees who are on standby as well.
Would that be open to any of our members that are in section chief positions or anything like that in the EOC, or would that be specific to one or two people, or?
I think it
who
applies.
exactly would
I think
that-
it applies to anybody who is required to be on standby. So for civilians, when we activate at a lower level, we're required to be within an hour able to report, or 2 hours able to report. So we're technically on standby. So any of those individuals would, if that applies to them as section chief, then that would apply to them as well. If they're identified as emergency management representatives, meaning they have to report to the EEOC.
Yeah, we talked about this some. I think we're generally possibly okay with this one. We just kind of want to clarify exactly who that is. Who's that standby pay open to?
So again, anyone who's required to report to EEOC. So if that's a requirement of your section chiefs, if they're assigned to the EEOC,
Can
then
the
yes,
chief
that-
maybe speak on this? Who that is? Who are we talking about?
Who are we talking about?
Who that is? Who we talking about? Can the chief maybe speak on this? Who that is? Who we talking about? Who that is? Who are we talking about?
Chief, can you come to the mic, please?
It could be individuals assigned to the Community Risk Reduction Division or individuals that are designated doing activation to report to the EOC as a section chief.
Which is what I said.
Just to clarify, we're talking about bargaining unit members, not civilian employees of our department,
Right.
correct?
Yeah, so if there's individuals in your department, I'm sure you've been up to the EOC, that have to come in when we are, and they operated and work at different desks in the EOC. When we activate, regardless of all of us in the city, those individuals, same as us, have to move in, and they get the call or get the text message that say, hey, move in. So essentially they're on standby. So we don't receive any special thing for that, but obviously if the arson investigators do, so it's just an additional incentive, but we can take it out.
So these are people assigned to emergency management?
Yes,
And then you said community risk reduction as well?
yes.
These would be eligible for this standby pay?
So it'd be community reduction. He just gave examples. They asked who those people were, but community reduction, but also section chiefs. So in the EOC, regardless of what your day-to-day job is, we're all assigned to different sections under the section in the EOC.
Is everyone in our department right now currently eligible and equal opportunity to become an emergency management representative? Or how do you become an emergency management representative currently? I don't know the process.
So I don't know how you become a section chief other than like those are assigned through the emergency management coordinator. There's Ms. Nobles, who's recently, she was a deputy, now she's a lead. She has additional individuals that she's assigned and reached out to both the police and fire chief over who needs to be over what. I know in the past, fire has been over the shelters as well as assisting with some of the property maintenance stuff. And so those individuals who are designed as section chiefs obviously are individuals who have worked in the EOC. So I don't know in terms of equal opportunity how that works. I know certain department directors are pulled in to be based on our training. So I'm assuming that they're either appointed or selected by the emergency management coordinator.
Yeah,
Based on skills and
Again, I'm
training.
just asking, I'm asking how, and I was wondering if we could determine how does a member achieve that title? Maybe this is a definitions thing, or maybe, we just could get an explanation. I don't know. I mean, who picks who these people are that would receive this extra benefit? Is it an appointed position? Is it a tested position, or people offered certain training, certain individual, I mean, whoever.
It's not
puts in a request for
tested.
training. Right.
Yeah, and I certainly can't speak for Chief, but I can speak as having been an emergency management coordinator for 9 years. And as you know, when you need people in these situations, you need them. And I think this is an opportunity for someone in your department to make more money and be there just by being on call or standby, because we need people. We need people available when something happens, and we're willing to pay them for this duty. So it's kind of an extra duty for somebody who wants to get paid 8 hours for standing by and might not get called, but we'd rather take that risk or rather pay somebody and we have a bad situation come through and don't have the people respond to it. That way we're guaranteed to have that fire representative in the EOC and communicate with you and communicate with whoever. And it was just a thought that we could have somebody that you could have. It's not a title so much per se, it's more of a duty for somebody to fill.
I totally agree with you that we need to have people do those jobs and that there needs to be someone ready. My concern is, how do we decide who those are through our department, the way we function with being a civil service department, when we promote up, and I guess I could see this as maybe a promotion or maybe a team. How do we determine who those people are moving forward? I realize there may be current people who fit that position now. How do we determine in the future who gets that opportunity for that promotion to be qualified for that extra money. And just a procedural question moving forward. Again, as Vice President Hendon said, we want to be agreeable to this. We think that it's a really good thing. Just have a concern with the process of how we determine who that is.
Yeah, and I would anticipate that being the chief to designate whoever that is for that position. Now, we can take it away. We'll pull it back if you feel that way about it.
So, Mr. Williams, it's my understanding that we already have personnel on standby for the EOC. It's the two chiefs that are in community risk reduction. Is that right, Chief? Yes. So is this different from that, or is this just formalizing them being paid for that in the contract? Because they've already been doing that.
It's a
And
formalization for that.
So this isn't going to be extended to any other member other than who's already doing this.
But it's also, like I said, it's available for sections if they're assigned as a section chief. The new emergency management coordinator has decided that she wants to expand those, so there it could be, again, opportunities for other members of the department to become section chiefs in different areas
And get that standby pay.
and get standby pay. The idea was to not make it complicated for individuals to volunteer and want those jobs, or to kind of be volunteering. We understand that some and most of the members of the department need time to move in, and so they should be compensated for that. Are we moving forward, or are there additional questions on that?
Not at this time. I don't have any. I don't believe anybody else does.
Do you want me to hold that one, or do you want to mark it for TA?
I'm good with it. I'm good with marking it as a TA.
Okay.
Sounds good.
Mark it for TA.
Yeah, thank you.
I do want to point out that we're approaching our 4-hour mark, so is everyone good to continue?
Sure, for a little bit, for at least another hour.
Okay.
I don't know your travel arrangements, Joe.
I just kind of, I just know, I'd hate to stop.
I'm good for another 45 minutes at least, but I don't know
Okay,
if maybe we could find a stopping point.
okay.
Okay.
We're almost done. I think we've kind of made it through. The wage table, obviously, will,
Yeah.
we were pretty far,
discuss that.
yeah, we were pretty far apart on that one. So if we can kind of come back to that one.
Yes, ma'am.
And address that later. We TA'd
On
in
insurance.
insurance, yes, sir. Let me just scroll past that. The next major section was the grievance section. The biggest change here is what we changed all the timelines to the same. So we went all 10 business days, all the same. And I'll let the city manager speak more to that if you wanted clarification. But the fundamental difference was to make sure that we streamlined the process so that there was no confusion. I know there was 7 days, 10 days, 15 days. So it was just really so that we can have a more streamlined process for responding. And I'll admit that the union's been gracious and given additional time, but also business days worked better in terms of travel and weekends for the city, so that, you know, that time with family could remain with time with family and not be up against the clock.
Yeah, and that one, basically, I think when grievance submitted to the local 399, you have, what, 10 days to get it to the chief or do something with it?
By the current article in our contract, a member has 15 days to submit it to
15
submit
days.
it to the grievance committee, where we in turn would have 15 days to determine whether or not it was an actual grievance and if it should proceed to the next level.
And then I think as it proceeds, those days change from, what is it, to 10 or 7?
10,
7, I
7,
believe. Yeah.
Sometimes I think
They're
it's
all over the place.
Yeah, it gets a little, there's some ambiguity sets in, and it's like, oh, do I have 7 days to respond to the union or not? So if those days can be consistent throughout the process.
I thought 10 was like kind of somewhere in the middle, wasn't trying to reduce it. We just thought that when you say business days, it kind of gives you the extra versus calendar days. It gives extra days because now you don't have to count the weekends or any recognized holidays. So it kind of evens out the time, but
We
flexibility.
have a counter on that with the same intent that you guys have, and We did stick with calendar days because our guys work on weekends, they work on holidays, they could be grieved at any time. But our recommendation was to change all of the days, just as you did to 10, change them to 15. We want the ability to be able to sit down and work together to solve these problems without wasteful spending in arbitrations. We want that ability. And I realize that right now, almost every one of them that we've submitted to you, in the last year or so, we've had to file extensions. It gets complicated moving forward, keeping up with timelines. So I totally agree with you. So our counter for the grievance procedure would be to change everything to 15 calendar days. Everywhere it talks about a day, it's easy to keep up with. It gives us the opportunity. It gives us time if we need time, but we can still work to resolve these as quick as possible. It just allows us the flexibility. But we do have a wording change that
Can we stay right there though on,
Yes.
on business? Would you be willing to meet in the middle and do 15 business?
Yeah,
That gives you more time.
yeah, perfect. That's fine if you want to do that. Yeah. Yeah, it would give us even more time.
We did 10 business. And they want to do 15 calendars. We want 15 calendars. Okay, the manager's fine with 15 calendar. What was your, so we'll mark that down and I'll make that change, 15 calendar. Yeah, and
All right.
then can
And
you
then-
just direct me to the page number at the top?
Page 25, section 3, subsection A.
Okay, page 25, subsection, what is it, section
A,
3A,
3?
yes,
Okay,
3A.
yes.
okay, got it.
It's representative, the last part, last two lines. It's a representative shall submit it to the city manager for changed adjustment to review. I'm suggesting a wording change to resolution. Review sounds like the city manager would just look at it and pass it along, but we're looking for resolution whenever we present these grievances.
Okay. Anything else?
Yes, with
That one
those
with
changes, we're
Okay,
good.
so
calendar days and then resolution.
15 calendar days, and then section 3A,
Yes, ma'am.
change review to resolution, and mark for TA.
Yes, ma'am.
Perfect. Now we're moving on to negotiation, page 28. I'm sorry, did I skip? Sorry, page 27. Nope. The complete,
Are you going to Article 33, negotiations to commence?
yeah.
thought we-
Let's get to
Didn't we?
that.
32, we T8 on that one, right?
Okay. So then we're good on that. And then the duration agreement, obviously, we can't have anything for that.
Right. I mean, are we on the same page? We're looking at a 4-year agreement in principle?
Yes, sir.
Okay,
So I guess we'll just wait and hold that one until
that's fine, but
conclusion of the contract.
that's where we're working at, right, at a perceived 4-year agreement, okay.
Yes, sir.
Is that it?
That's a complete for changes. If you want to go back through, so we can just make sure we have a clear understanding of what we're TAing. We still have management rights to discuss. General provisions. We're scheduled that one for TA with the changes that it shall now read, the employer agrees to furnish and execute a copy of this agreement to the union. The union shall receive a hard copy and electronic copy.
Yes, ma'am.
And so that one is scheduled for TA. Union business, there was some additional counters throughout the document, so that we're holding that one for a counter. Seniority and promotions, we're holding.
Yes, ma'am.
We are looking for definitions on the maintenance and standards section, so we're holding that one as well. On the department committees, we're holding that one for a counter.
Article 10.
Yes, for a counter. On vacations, we're holding that one for a counter as well. We are TAing payroll deduction with the change of changing the last union to bargaining unit. We're holding pension.
Yes.
And then the next ones were educational incentive, education pay, and certification pay,
And incentive pay, right?
and incentive pay. We're also holding that one for.
Maybe we can.
And then I also made a note to add dive team under incentive pay with the specific language. So the next red line agreement you'll see will have that.
Okay.
Okay. The next one we've already agreed on clothing. Mileage, we were going to look into how that, but essentially that one could possibly be a TA depending
Yes,
on
ma'am.
original language.
Yeah, we'll take a look at that one.
Yeah. So we've marked it as a potential. Hours and overtime, we have holding that one for a review on section 2B. We're good on callback. We have industrial fires as a potential TA once we have the language moved. We're holding temporary promotions for further discussion.
Yes, ma'am.
We're holding hiring procedures for additional discussion and potential cadet pay discussion at the next meeting. We have standby pay as a potential TA. We have wages for additional discussion. Insurance was previously TA'd. We have the grievance procedure marked as a TA with a change for 15 calendar days. And section 3A to change reviewed to resolution. And the rest of them, we're just gonna hold until the completion of the contract.
Okay.
I would just, like, while we have everybody here, the one major change that we did to the wage table, not including the percentages, but we did add the assistant chief to the wage table. Just wanted to see if there was any discussion or heartburn about that, so we can have a better understanding. We talked about this at the conclusion of the first meeting, but just wanted to make sure and have it on the record that there's not an objection to that.
So there's been a prior agreement in our contract, is listed in the contract right now as the city sets the wages of the assistant chief. Are you guys suggesting that you want to change that and then now the union would set the wages of the assistant chief?
So no, so if you go back to the wage table in the contract, and let me put it up on the screen for everybody to see. The assistant chief is entitled to contract benefits, and they're entitled to that. That's in the contract. Just give me a minute. Let me scroll up. And so it says here, the employer, it said previously that the employer will set the wages of the position of assistant chief. That's always been the case, but it always said that they were a part of the addendum. So my thing is, like, in past years, that he's still a part of the bargaining unit. Him becoming an assistant chief doesn't make him a civilian, so he should be entitled to all contractual benefits, including wage increases. And so I just want that clarified, because he's not a part of the wage table. That's been a source of contention, and I believe that that's essentially unfair. Not to argue on behalf of your member, but I think that that's grossly unfair. And if I was in the department, I would not want to, accept that if that means I was going to give up contractual benefits.
Right. We're fully aware that he's part of the bargaining unit. He has to be part of the bargaining unit by law. that particular article was changed somewhere around 2010 to 2012 for a specific reason, and it was changed by the city. If y'all would be agreeable, we could get that contract and we could bring it in and we could talk about the history of it and why it was changed. We're not necessarily against any
So
of
I'm
this,
not-
but it's
I'm not
good to
interested
talk
in-
about
yeah.
why it's the way it is, because
I'm not interested in litigating like past issues. I think that it's fundamentally unfair for a person to receive a promotion and then lose out on potential contractual benefits.
we're not saying that. He should have never lost any of that, is our opinion.
So I can't defend what happened previously, but I can make it right. And so my thing is like making sure that he's a part of the wage table makes it fair and right, and it eliminates that confusion.
If the city
10 years
sets,
from now.
if the city sets his pay, and then we bargain and he gets raises, what's the intention of that language being in there? Because now from contract to contract, the city's not setting his pay unless the city is saying that they want to come back and adjust his pay or the assistant chief's pay.
So the city sets the base pay. So I think it was intended that when the assistant chief became assistant chief, the city would set the base pay, but he would still be entitled to contractual benefits. Same way we set entry-level pay for a grade 1 firefighter, but then you contract for what they make later on. We would set entry-level pay, and then he would still receive contractual benefits. And if that was confusing language, then we can fix it. But I'm saying him not getting contractual benefits is counterproductive to the contract.
Now that we're bargaining for all employees that work in the fire department, did there need to be any extra classifications made into this schedule?
You want to clarify that? Because we're bargaining on behalf of firefighters.
Okay, that's what I needed to know.
So there's no issue with the assistant chief being part of the wage scale?
And like I said, we can change that language where it says set wages and we can change that to clarify that it's,
Contractual.
it sets base his initial salary. But I believe that when you negotiate for raises for your members, that would also include all ranks.
I would just say we would need to hold on this and we would come back, I guess, and discuss it. Or are we about to discuss our actual wages? Are we going to be breaking today?
I'm looking at your negotiator.
Yeah.
He's shaking his head no.
That sounds.
We're pretty far away,
Yeah.
so I think that would be a,
So my question was solely for adding,
Right.
was solely on the addition of him to the wage table, not on wages, but just the addition to that section of the wage table. And if we,
I think we can come back to that.
Okay, so we'll hold on that one. Whatever we do, and I think we're having good conversations today, and we've had some really good conversations that we need to have. But I'd like to be mindful of citizens' dollars as we sit here. We're it's costing a lot of money to do this. So I'd like to, in our discussions, if we can put a couple of days together and let's have discussion on consecutive days. If we can make our calendars work, and that way it cuts down on travel and Joe doesn't have to jump around the airports and stuff. So if we can look at our calendars and pick out a couple of days that we can work, or either we don't have to do it today if y'all don't want to, but.
right, we have the 12th schedule, correct?
Yeah, we have the 12th schedule already.
And I'm sorry, I thought I looked at my calendar, I'm in San Antonio for a
The 13th.
sector local thing. So
and I believe that impasse date is the first day of December. So we're obviously gonna,
I think we identified December 9th, right?
that's that Monday, the second.
The 9th, yeah, the second week. I mean, we want to stay at the table. I mean, from our point, we're willing to file extensions as according to, 174. But the holidays are coming up. You want to keep the 12th
Keep
for
the
now?
12th and then try after that, get a couple of days together.
I can shoot you some dates that would work, hopefully in that next following week. Because the next week is Thanksgiving week, correct?
So the next
2
week after is 2 weeks away. So the Thanksgiving will be the week of the 25th. And I know for the city that the week of the 18th is not a good week. And then we have the week of that.
Well, let's keep the 12th.
This room isn't available the first week in December with the exception of Monday. So we wanted to, again, maintain cost and expenses by saying in this particular venue, Monday, December 2nd, and Friday, December 6th.
This room is available the 3rd, 4th, and 5th?
No, it is not.
It's not.
No, sir.
Is
It's
it,
available on the 2nd and the 6th. And this is not for you to decide right now. This just is when you're looking at your calendar. I just want you to know what we have in terms of availability for this room. The 6th, the 2nd, the 6th, the 10th through the 13th. And then the 18th through the 20th is available, but the last council meeting of the year is December 17th.
so you said it's available the 2nd and the 6th of December,
Yes,
the 10th through the 13th,
yes.
and
The 18th through the 20th, with the last council day being the 17th. So we wanted to get a contract ratified this year. The 17th would be the last meeting to do that, which means we would need to have a formalized agreement by the 12th.
is changing locations, I mean, if we can't use this room, can we use another room or go somewhere else?
So at the request of union, we chose this room because it's the least, it already has the equipment set up. If we had to outsource it, we would have to bring in additional equipment for microphones in order to record and live stream. That would be the only.
Yeah, this was just my suggestion to save money. We're open to move.
You are?
Yes, sir. This was just my suggestion to be here, being that the city proposed live streaming and having everything open to the public to be, for everyone to be able to view. In an effort to save money, we suggested that it come here. I'm open to move anywhere.
But at what cost? Are we?
So in order
Because I'm
to,
sure you want to, I would like to keep it streamed if we could, where people could see it now. But that's negotiable too, so.
Yeah, let's have some discussion on
so
that.
the cost to, I can tell you that the cost to live stream each meeting would be upwards of $5,000. The last numbers we pulled. Yeah, so, yeah, and that's if we stay within the 4-hour range. If we wanted to go longer, extend the date, the cost could potentially go up.
Okay, well,
So currently we're using staff resources. So someone's here as part of their normal job operating. If we operated outside of that, then we would have to, we don't have the equipment, so we would have to outsource it. So we'd have to rent that.
so someone's on overtime right now.
I think he'll probably get comp time, I'm sure.
Okay, well, let's keep the 12th, and we'll take those dates into consideration, and I'll get back with Mr. Williams and my team on that. Does that
Sounds
sound okay?
good.
Yeah, we'll keep the 12th, and then we'll work something out after that. Thank you.
Okay, is there anything else from anyone? Well, thank you, appreciate it, and look forward to our next discussion. Thank you.